Thank you, Ian. I gave you 1 minute and 45 seconds on behalf of Legal History, so I just want that recognized. For people who don't think I have any sort of empathy, I do. John, it's over to you. John Hunter, who will be speaking about professional education in the modern law school.
Well, only a bit. Thank you very much, John, and thank you to Dean Bryden and to the organizers for inviting me. I think if I understand the program correctly, that I'm the only Canadian practitioner who's been invited to speak to you, and also the only sometime regulator. So I feel a burden of responsibility to stir the pot a little bit, and I will try and do that. But I'm appreciative that you would have me back, particularly after what I have wrought in the last few years. I didn't actually come to talk about the task force report. I came to talk about professionalism. And I wrote a paper, which you have access to if you want to look at it, about the importance of professionalism and the role that law schools can play, and I thought ought to play, in inculcating their students in the values of professionalism. And I took as the initial guide the Carnegie Foundation report that you heard about this morning, which lays out, I think, a very strong pedagogical rationale for introducing legal ethics and professionalism at the law school level. And I've made some comments in my paper. I'm not going to go through that. I think David covered that ground so very well this morning that I don't want to tread on what he has said. I want to make a couple of comments supplementary to his presentation, and if you want a few additional references, I do have the paper that you have access to. He mentioned the Carnegie Foundation. As you know, I think the Carnegie Foundation report ended up really talking about two areas in which they thought law schools ought to move, both Canadian and American, on a go-forward basis. One was to introduce legal ethics and professionalism more fully into the law school experience, in large part to help establish the professional identity of the young lawyer, the lawyer in training in effect, or the student, let's call him, or her. To do this at the law school level was important. The other, of course, was the integration of the practical and the academic, and that's something that's been the topic of much discussion today, and I'm not really going to talk much about that, other than to say that it seems to me that it's a very soundly reasoned approach to the role of the law school in the present as well as in the future. As I think you know, the task force report recommended a national standard which included a standalone course in legal ethics and professionalism. That is, in fact, the only course that is required under the national requirements that students take. I'm going to talk a little bit more in a moment about the national requirements, but I think you may all have the impression that we have laid out a list of courses and mailed them off to the deans and said, you have to teach these courses and show us that you're doing it. And it certainly wasn't our intention to do so. I don't think we did do so. I think we actually did what Daniel Jutra was suggesting in his question to Professor Arthurs. We tried to stick to our side and our responsibilities, ours as regulators, and leave legal education to the educators. But I'll explain how we did that, and you can judge for yourself. But on the subject of professionalism, we thought it was important, and we did make that the single required course for a student who wanted to enter the bar. Professor Arthurs has commented earlier today, and he's commented elsewhere, that there isn't really empirical evidence as to whether there are any particular courses that are more valuable for a practicing lawyer than not. And I think there's a lot of force to that. And when we did our report, which was from 07 to 09, we really didn't have a lot of empirical evidence to work with and didn't generate any, which is, I think, probably an area in which we could be criticized. But I can say that there has been some empirical evidence developed since then that is useful in this area. The Federation of Law Societies itself has now got a second project in place, and that is to determine the requirements for the entry-level lawyer. And this, of course, is in light of the fact that law societies have the statutory responsibility of accrediting lawyers for practice in the various provinces and territories of Canada. And so what has been attempted and is still in progress is the development of a standard not just for entry into the bar program, which was our task, but entry into the profession. What does an entry-level lawyer have to do? And what that group did, having a bit more of a budget than I did, is they went out and hired a third-party consultant to do the survey work that would satisfy them that they had an objective and defensible basis on which they could say these types of competencies, if that's the way it worked out, are required, and we should, as accreditors, require this for members of the bar. They surveyed lawyers in their first 5 years of practice. They asked them, what do you do? And what do you consider to be important in terms of knowledge, skills, and I think they surveyed on ethics as well, in what you do. And they assembled the material back, and it's all been published and available to you. So there's some empirical data on what lawyers who are actually practicing law have found to be important. I was, and certainly ethics and professionalism is on the list, and the other things that we ended up with as competencies in our task force report are all very much on the list. There are a couple of additional matters on the list, which I was disappointed to see because I thought it complicated matters somewhat, but there it is, at least it's empirical data. The United Kingdom has done some work recently on legal education, as I'm sure you're aware. They published a report this summer, and they included in that report, the Legal Education and Training Review, a tabular information on empirical data that had been produced in the UK by asking various types of legal professionals what they did and what they regarded as important in terms of subject areas. And I was personally rather pleased to see that the very top of the list right across the board was legal ethics and professionalism. That was what the lawyers and other legal professionals in the UK regarded as the most important subject area in terms of what they did. So we are starting to develop a little bit of empirical evidence now on terms of what's important and what isn't, and frankly I think this would be a wonderful area for those of you in your law faculties wondering what kind of research project to undertake, because the more data the better, but there is at least some there now. Two more brief comments on professionalism, and I'll talk a little more about the task force report. David made a caveat this morning about critical thinking. Was critical thinking in jeopardy if professionalism became really a core value in a law school? And I don't think there's any reason to be concerned about that at all. The reality is that many law schools now, including this one, have strong legal ethics and professionalism instruction. And I try to keep up, don't do a terribly good job of it, at some of the publications that come out, and there's certainly no evidence that I can see that critical thinking is taking a back seat to the analysis of problems of ethics and professionalism. In my paper, I've tried to list the number of cases that the Supreme Court of Canada has decided in the last 15 years on matters that relate to lawyers, ethics, professionalism, conflicts, those kinds of questions, and it's something around 15, 16 cases. It's, I would suggest, more than almost any other field of law outside the charter and criminal law. So there's a wealth of material to work with there, and I don't think that you need to be concerned that by focusing in on professionalism as a core value in the law school, you're going to find that critical thinking suffers as a consequence. And the final comment I wanted to make was a very brief response to Alice Woolley's question to David about what about the client. I think I know where that's coming from, and I just want to say that without going down the whole civility path, that We'll do that afterwards. I really want to commend to you Michael Code's paper of a few years ago. Michael Code, very experienced criminal lawyer, now a judge in the Ontario High Court, where he talked about the relationship between professionalism and a fair trial, and how lawyers' professionalism makes the system work, and how a lack of professionalism doesn't. So I think that the client is going to be well represented by a lawyer who exhibits professionalism, and it shouldn't be a concern, but that is a larger topic than I was going to speak to today. All right, what about the task force report? Why did we do this? Are we really trying to colonize you? I don't think so. Are we trying to run legal education? No. You're the educators. The regulators know perfectly well that you are the ones who do this well, and we wouldn't. But everybody has their responsibilities, and I think the foundation of the issue as it arises is maybe a difference in view as to whether the law school kind of exists in splendid isolation, or whether the law school exists as part of a larger structure in the legal system with larger roles. And I've heard a lot of suggested missions for the Law Society today, and I don't disagree with any of them. And I don't think any of them is particularly inconsistent one with the other. But I think if you view the law school as existing as a silo in a sense, then some of these arguments can make some sense as to whether or not one should completely forget about any practical application of what it is that you're doing. But if you view it as part of a larger structure, I think the practical application issues are very, very difficult to avoid for many of the reasons that Ian just gave and for reasons that the Carnegie Foundation has laid out in its report. Your responsibility is to provide a legal education, and I would hope to say a professional education as well, for those who intend to go on and have a legal career as professionals in the legal profession. The responsibility of law societies, among other things, is to accredit lawyers. And law societies have that statutory responsibility. So what is an accreditor to do? Well, an accreditor normally will set standards. That's true in any kind of profession in this country, and it's true in other legal professions in comparator jurisdictions. We have not had a national educational standard in Canada ever. That's not true of other countries, but it is true of our country. And so the task was to try to develop a national educational standard that met a lot of criteria. One of the problems we had, as you know, is the large influx of foreign-trained lawyers, some of whom are foreigners who are emigrating. Someone's got a Polish law degree and has been practicing in Warsaw for 10 years. Someone who's got a degree from the University of Pretoria or something of that nature. But a lot of Canadian students who couldn't get into law school here and have gone abroad and want to come back. How do we treat them? What do we require of them to come into the bar program, and can we require something separate of them than we can require of our homegrown students? At the same time this was going on, there was fair access to regulated profession legislation developed in Ontario and Manitoba and Nova Scotia that required the professions to be more transparent as to what their requirements were. At the same time that was going on, the law societies had enacted mobility agreement some years ago, allowing lawyers to move back and forth in such a way that every law society basically had to accept any lawyer from any other one. And we generally think that's a very good thing for the profession and for the clients that we serve. So all of these things led to a conceived need to have an educational standard that was transparent and defensible, and one that would apply to all. We developed that as best we could, but we are also very conscious that law schools here have been without such a requirement for a very long time. I would add parenthetically that I think sometimes the Ontario mythology, certain elements are forgotten, and one of the elements is that in 1957, when the Law Society did relinquish control of legal education, it was on the basis of a strict list of courses that were to be taught by the law schools and another list of courses that had to be offered by the law schools. It wasn't a wholesale walk away. It was something that was set out in a way that the Law Society could be satisfied that the students were going to be taught certain things. And that was amended in 1969 and then hadn't been touched since. So that was the sort of context in which we went about the work. We didn't do a number of things that I think you could legitimately have been annoyed at us about. We didn't come out with a course list, which is what most regulators do. It's the approach that's taken in the UK and Australia and New Zealand. They've got course lists. You've got to take the courses if you want to practice law. We didn't do that. We said we're not interested in the input side of it. That's for you. You decide what you want to do in terms of the teaching of legal education. We're interested in the output. Ian was just talking about what we teach versus what we learn. We're interested in what the student has learned, not what the course name is or how you do it. And so the competencies that we developed or articulated were competencies that are outcomes-based. And so however you get there is up to you. You don't have to have a course in each of the itemized areas of the competency, but you have to satisfy yourself and to some degree the people in our organization to look at it. You have to satisfy them that it does have that effect. The student will have achieved that knowledge-based competency and certain skills-based competencies. Haven't had that before. That's not been a part of the requirement in the law societies. It's not a part of most requirements in comparative jurisdictions to have any basic skills. So that was there. And then we did say, got to have a course in legal ethics or professionalism. Now, Dean Jutra said, well, why wouldn't the deans just say, all right, you're regulators, you got to regulate, you do that. We're educators, we'll do our thing, leave us alone. We actually did. You might think that from what you've heard that we said law schools have to do something. Law schools don't have to do anything. You don't have to teach any of these courses. You don't have to, your deans don't have to write any letters. The regulators have no jurisdiction over law schools and have not asserted any jurisdiction over law schools. You can do anything you like, but if your graduates want to practice law, then they have to come through us and they have to meet our requirements. And what we have said is to try to make it easy for you, we'll accept any Canadian law degree where the dean says to us, with some degree of support and substantiation, all of our graduates will meet these competencies by virtue of the program that we offer. And we also said, if you don't want to do that, you don't have to do that either. If you want to have a program where some of your students will meet them and some of them won't, that's fine too. You tell us which students meet them and why, and we'll accept that. We don't have to approve your program. We can approve it on a student-by-student basis. The ultimate end of the road is if we can't be satisfied that the students have these competencies as an accrediting body, well, we do have an option. We have an option of the NCA. The NCA has a whole series of examinations. John McLaren said this morning, the profession doesn't want to do the legal education, and he's absolutely right, and isn't capable of doing it, and that's partly right. It certainly wouldn't be done as well as it's done in law school. But there is a whole series of examinations set by legal academics from your law schools, marked by legal academics from your law schools, that the NCA students have to take and have to pass. So if your students don't take courses at your law schools that give them the competencies that the regulator thinks are essential for an entry level, for entry into the bar program, that's fine. We'll send them to the NCA and they'll take the exam there. And you can decide for yourselves what your students' reaction to that would be. But don't rail on us for telling you what to teach, because we haven't told you what to teach. We've told you what we require as regulators in order for people to enter the bar program. So I hope that that helps a little bit in clarifying what it is the profession's done and why we've done it. And it isn't really a designed effort to take over legal education. In fact, it isn't that at all. Nobody I've spoken to wants to have anything part of that. You're the educators. You're the pros. We're happy to have you do all of that and just tell us it's been done and show us it's been done to some degree, and we'll all accept that. But I think if you accept that the law school is more than just a silo, but is part of a larger legal community, I hope that you'll appreciate that that the regulators are trying not to interfere and trying to interfere as little as possible with how you organize your programs, but nevertheless have their own job to do. And their own job, a statutory mandate for accreditation, is what we've tried to do. So that's what I thought might be of some use to you. I'm going to wrap up, but I just want to say one other thing, and that is Ian's paper talks about solutions orientation in law school, and I thought that was terrifically well thought through and presented, and I hope that you'll all take a look at his paper and think about that, because that is what we do in practice. It is about solutions. It's not about problems. Our students coming in can all identify all the issues in a problem and can see where all the problems lay, but we have to find out what the solutions are for the client. So if you can help with that, you're doing a real service to your clients, who are the students who come to you for a legal education. Thanks very much.